How did you get interested in the ideas and topics that you talked about in your panel earlier today?
Sure. Well, I spoke about some of the legal themes that dominated the 20th century and how those tied to the principles espoused in the Declaration and to some degree the Constitution. I guess those have been interests of mine, excuse me, the entire time I've been a lawyer and even when thought about going to law school. They sort of reflect on the proper role of a judge, and now that I'm a judge, these principles hit home even more. Excuse me. But I wanted to speak about the ways in which courts need to properly interpret the Constitution, which reflects principles from the Declaration, and the ways in which judicial decisions can really upset the balance of power between states and the federal government, can impact the separation of powers at the federal level, and I tried to give some examples of those from the last century.
What do you think was the most important topic you discussed? What would you want a viewer to walk away knowing?
Probably some of the issues that are tied to the Warren Court, which was the Supreme Court sort of during the 1950s and 1960s. The Chief Justice was Earl Warren, so the courts are often named after the Chief Justice. We're currently in the Roberts Court era, a much different era. But that court is well known for I would say aggressive, expansive interpretation of the United States Constitution in a way that enhanced the power of the court, or at least the decision-making coming from the court had far more significance than cases of earlier days that sometimes curbed the power of other the executive or legislative branch, but also curbed the power of state governments to enact laws as they saw fit. There were additional constitutional rules announced by the Supreme Court that in many ways tied the hands of state legislatures, which is tying the hands of the voters who elect the legislature. But probably that was the most important theme. It's a theme that's even sort of still present today at the court when cases are decided. There's a majority of the court that I think views themselves as originalist judges who are trying to be faithful to the original public meaning of the Constitution and to sort of limit the role that judges have in sort of the policy-making space and preserving the opportunities for liberty and self-governance. So it's an ongoing issue, but some issues were highlighted, I think, during the middle of the last century.
Do you see any way to try and reverse that sort of large-scale expansion of the Constitution back to something more like what Calvin Coolidge might have espoused?
Yeah, I'm an intermediate court judge, inferior court judge is what we're called in the Constitution, so this would be beyond my authority. But for the Supreme Court, occasionally they will overrule decisions, but that's uncommon. But they can, change the trajectory of law in certain ways, and I think you've seen a lot of decisions from the Supreme Court that are more reserved or less expansive or more deferential to legislatures or to states. So I think there's some arc in that direction, but there's a lot of decisions that I don't think will ever be reversed. Justice Thomas, among other current justices, writes in a number of areas where he identifies places where he thinks the court has gone off on the wrong track, whether it's Privileges and Immunities Clause or incorporation or other issues. But he oftentimes writes alone, and probably quite a big lift to get 5 justices in that direction, but we'll see.
What do you think is most misunderstood about the U.S. court system?
That's a good question. I probably depends who you're speaking to about what they misperceive. So, a common misperception, might be the role of judges, which is sort of consistent with the points I've been making. That being that, there's 3 branches of government, but I think of 2 branches as the political branches. You have the legislature and the executive, and they are really trying to be reflective and responsive of the public will. But judges serve for life and have a very different role, and so they have to make calls on whether those 2 branches of government are acting within the bounds of their authority. But I think people sometimes think judges are kind of doing lawmaking themselves, that they are deciding what they think the best understanding of the law is, or the best understanding of the Constitution is or should be, and imposing sort of their values, what they want the law to be, or how they think the law should be. And I don't think that's what judges should be doing, but I think there's some thought that maybe the courts have become sort of politicized in a sense, and that judges are really just sort of legislators, but it's a smaller body, 9 at the Supreme Court or 3 on a panel in the Court of Appeals. They're just picking and choosing their policy preferences when they decide cases. That's not what I try to do. That's not what most of my colleagues don't try to do that. But I think some people probably have the perception of judges as being almost as political as what I think of as the truly political branches of government.
Is there any idea that you didn't get to discuss at the panel earlier today that you'd like to expand upon more about the court system or your job?
Yeah, well, there's a lot of issues to discuss, but I tried to pick some highlights since our assignment was the 20th century and changes in the law coming from the courts and the sort of downstream effects that's had. And I guess you could fast forward that conversation to today, as I've mentioned, where a lot of these same battles are still occurring, although there are places where I think the court is trying, on the margins at least, if not more, to change the trajectory of law in some ways and get back to a more originalist interpretation of the Constitution, one that, again, leaves a lot of power for elected members of government and for the states to legislate as they see fit. And the corollary where the courts sort of aggressively interpreting the Constitution and sort of finding new constitutional rights, those might be very popular decisions. They might be unpopular. I don't know. But the point is that once the courts have decided something at a constitutional level, there's no room left for elected officials to change the law, and that then sort of does freeze out the voters and the people. So it's an ongoing battle, but I think there's more movement today to try to ensure that there's room for democracy and Republican form of government to prevail, and that the courts kind of honor their traditional role the framers identified as the least dangerous branch of government.
Finally, do you think Calvin Coolidge's positions on the Declaration and the Constitution are still relevant today? And if so, what should viewers know or take away about those positions?
Yeah, I think Coolidge had a limited view of government, both a limited view of what the federal government should be doing, and then a limited role for the courts. And I think all those themes are still relevant today. Obviously, the federal government has expanded dramatically, but that doesn't mean that courts can't still try to, stay in their lane and issue sort of, incremental, minimalist decisions whenever possible, rather than sort of broad, sweeping decisions, which I think is a view that Coolidge would share. One thing that's quite different today from 100 years ago is the Congress, at least to my perspective, feels pretty dysfunctional and doesn't legislate in the way that certainly Congress has at different times over its history. And that's putting more pressure on the executive branch, I think, to sort of fill in the gaps and take policy action because Congress hasn't spoken to something. This happened a lot in COVID. It's happened a lot with immigration. There are a lot of other examples. That is then putting the courts in difficult spots because we're having more litigation. More things are coming to the court where it's executive action rather than sort of legislative action that's being challenged. And there's, the executive can only operate insofar as they've been authorized to do by the legislature, unless it's a core power that the president enjoys in the Constitution. But on a lot of domestic issues, the president is really acting based upon whatever authority the Congress has given the president. And so we've had a lot of issues surface that the Congress hasn't spoken to directly, and the presidents have tried to address, and then inevitably, because we're a pretty litigious society, those things end up in court. And so judges, I think, are being asked, are put on the front lines a lot more to decide these sort of difficult cases that have political underpinnings. I don't think the judges are acting politically, but the cases that come before them have political significance. And so that's probably a difference from 100 years ago, where you had more legislative initiative and efforts, and probably courts being a little bit less involved in deciding the issues of the day.